Brownlee.
Mr. Speaker, I seek leave to move a motion, notice of which was lodged this morning, relating to the adoption of the changes to the standing orders recommended by the Standing Orders Committee for the registration of members' pecuniary interests.
Leave is sought for that purpose. Is there any objection? There is no objection.
Mr. Speaker, I move that Chapters 3 and 8 and Appendix B of the Standing Orders be read as if amended in the manner set out in Appendix 1 of the report of the Standing Orders Committee on the review of standing orders relating to pecuniary interests 1.18a, with effect from 1 January 2011. Mr. Speaker, the Standing Orders Committee has reviewed the standing orders relating to the pecuniary interests of members of Parliament and has recommended a number of changes to these provisions. The motion adopts the committee's recommendations by way of a sessional order with effect for the round of annual returns due in February next year. The referral of this review followed a unanimous recommendation of the Privileges Committee in September of 2008. The Standing Orders Committee heard evidence from Dame Margaret Baisley, Registrar of Pecuniary Interests, who made a number of suggestions for improving and clarifying the requirements for the declaration of pecuniary interests. After presenting her submission, Dame Margaret was appointed to advise the committee on the review. The committee also heard from the Provost, Controller and Auditor General. The register is a public record of specified financial and other interests that are personal to each member. It provides information about any interest or other material benefit that a member holds or may receive which might reasonably be thought by others to influence his or her actions as a Member of Parliament. The purpose of the register is to strengthen public trust and confidence in the pecuniary parliamentary process by improving transparency, openness and accountability. The Privileges Committee emphasised in their report such principles, and the Standing Orders Committee recommended incorporating them more fully in the House's rules. Some new requirements have been recommended. For example, members will now be required to declare an interest in trusts of which they are trustees without having a beneficial interest. Members must also declare a beneficial interest in a trust regardless of whether it is a fixed or discretionary interest. Recommendations also clarify requirements for the declaration of real property and paid activities. The committee's recommendations mean that some additional areas of interest may be declared that are not strictly pecuniary or financial benefit to members. For this reason, the committee has proposed that the name of the register be amended to Register of Pecuniary and Other Specified Interests. A significant new development is the introduction of a new procedure for members to request that the registrar conduct an inquiry into members' compliance with the obligations to make returns. On receiving a request, the registrar will then consider whether to conduct such an inquiry. This means that the Speaker will no longer be involved in the considerations of such matters. After conducting an inquiry, the registrar will have the ability to report to the House that a question of privilege is involved. But that outcome would result only from the most serious situations. In many cases, matters may be resolved through the correction of returns, which is of course not currently available to the Speaker when considering matters of privilege. The Registrar's new inquiry role replaces that previously accorded to the Auditor General. It's worth noting that the Auditor General never exercised this function, as there were doubts as to whether there was sufficient statutory power to do so. However, the Auditor General will support the Registrar when required. In recommending this new procedure, the Standing Orders Committee was concerned to prevent its use for the making of frivolous and vexatious requests for inquiries into members' interests. A member wishing to make a request must have reasonable grounds to do so. A member who makes a request without those reasonable grounds will risk being held in contempt of the House. Mr. Speaker, the sessional order will have effect for the 2011 returns. In the light of experience from the returns process, the Standing Orders Committee will consider how these recommendations should be adopted as permanent amendments to the standing orders. Mr. Speaker, in addition to those notes, might I say the process of members recording their pecuniary interests has been in place for just a few years. And, Mr. Speaker, I think it's fair to say that some members, in fact large numbers of members, have been overly cautious about what they do put in there, to the point that we now do get registers of interest as opposed to necessarily pecuniary interest. So in many ways the changes codify what has become a practice for members anyway. And I think it's fair to say that most members have erred on the side of caution when making their returns, to the extent so that some members do appear to have interests far in excess of the actual benefit that may be coming from them, simply because they felt some association with an organisation or with some real property or with any range of other financial instruments might and somehow be required under the provisions. What this arrangement does effectively is confirm that, so that there can be no doubt in the public's eyes about who has what interest and where. I think the issue of going to the registrar of the interest, having that right to inquire, is a good one, because clearly in most of these cases they will be just simple omissions that people have made without any desire to hide stuff. I'd suggest that if there was anything big and large, where there was even a hint of pecuniary interest being concealed, New Zealand is a small enough country for people to know about that, for it to make its way into the system and for there to be considerable concern expressed about that. But there will be cases, sir, where people don't declare things simply because they don't know about them. The case would be, sir, of perhaps a defunct insurance company that had small residuals left over. People may not even remember owning a particular policy, but at some later point they're contacted by an investigating organisation to see if they are the person named on that policy, and then a small payment is made out to them. That may not have been declared in the register, but it was not deliberately concealed, and I think those are the sorts of things that can be very easily sorted out by the registrar. If it's a bigger matter, then the Auditor General stands by to assist in that process, and ultimately everything comes back to the House for the Privileges Committee to deal with. Mr Speaker, I don't want to make any further comments. I believe it is a positive move for the House to adopt the sessional order.
The question is that the motion be agreed to. The Honourable Trevor Matter.